This is the wrap-up voiceover for Class 2, which was delayed, alas, because of a problem with the technology. So Class 2 focused on intellectual property, and I tried to sketch out the different excuse me, issues and different types of intellectual property and different situations that they might match to. So, excuse me, one line I tried to draw was a line between functionality and expression, and the functionality line is to say that we have rules for protecting, as it were, inventions, and those typically are the rules of trade secrets and the rules of patents. And then we have other rules, which are about protecting expressions, ways of articulating something, symbolic speech, as it were, but speech primarily. And so copyright does that, and trademark does that as well. And so we want to separate those two, which path we're going down, whether we're going down a trade secrets path or a patents path, really is whether we're talking about functionality, and whether we're going down an expressive path, a symbolic path, really focuses on this idea of copyright or trademarks. Now, there are quirks here. So the trade design, the design patents that we saw at work in the Apple-Samsung case are really incredibly quirky in the sense that it's not about functionality, it's just about ornamentation. And you might think that we would protect, to the extent that we were going to protect ornamentation, we might do that through the copyright system and not through these design patents. So recognize that like most simplifying ideas, it doesn't necessarily capture everything. All right, on trade secrets. So the idea of a trade secret is that we're going to protect some sort of, as it were, invention. Though invention is in some sense too narrow a conception for trade secret. A customer list will qualify as a trade secret, even though, or can qualify if you take the requisite steps to protect it, even though we wouldn't think of a customer list as being invented in any meaningful sense. So the kinds of situations where a trade secret regime may apply is actually in some sense broader than maybe what we would think would apply in the patent context. As indicated in class, trade secret law is actually, there are different ways of approaching it. So there's a common law of trade secrets, meaning judge-made law, but there's also state statutory law in the form of the Uniform Trade Secrets Act, but also federal statutory law, so the Economic Espionage Act. And if one wanted to identify a trend, I would say a trend towards federalization, mainly because in olden days maybe trade secrets was a domestic issue, but now it's very much got an international flavor to it, where content is seen, or where inventions, ideas are seen as leaving the country and going overseas. One of the bright line differences between trade secrets and patents is, of course, the idea that the patent system requires a filing which eventually becomes public, while the trade secret system is tied to secrecy, so no filing at all. And a trade secret arises on its own without any affirmative grant by the government. Patents are obviously granted by the government. Trade secrets there's no filtering system for those, and in some sense you discover you have a trade secret sort of only after the fact, when an issue has arisen, and where you want the protection of the trade secret regime, where you then may be asked to establish that what you have done qualifies for trade secret status. Trade secrets are also of unlimited duration. It's very different than patents, and the core protective scheme under state law is the idea that trade secrets are to be protected from misappropriation. We see trade secrets arise, the statutory regimes that we see applicable to them, the context in which we typically see them at work are as I indicated in class, contractual settings are very important between firms and employees. in between one firm and the firm maybe it's licensing to. And we'll see an example of that when we get to the last day of class in the Tian Rui case, where we'll deal with some international issues where there will be a trade secret overlay to that. All right, on patents, a key conceptual part of the patent system is the idea of filtering. That when you seek a patent, there are standards that have to be met. Lots of complaints that those standards are too weak, that the United States Patent and Trademark Office, the PTO, is not sufficiently demanding. But on paper at least, there's a meaningful system here that requires novelty, utility, and non-obviousness, where non-obviousness is the idea that the invention has to be a sufficiently large leap that you should get a patent, that an invention which would have been obvious to anyone who was sophisticated in the field, who understood the field. Those kind of inventions, which we think would occur naturally, we don't need to incentivize those. And so we don't hand out patents for those. It's only things which were not obvious that are entitled to patents. Distinction between inventions and ideas. So the notion is that you need to actually have something that's working, as opposed to just an idea about how something might work. And then we noted in class that the United States is in the middle of a transition. The United States had been for a very long time a first-to-invent system, which meant that your priority in the invention system, the patent system, is very much a priority system. Who comes first? Who gets the patent? Who comes second? Who gets nothing? The United States had been a first-to-invent system and is now transitioning to a first-to-file system. Patents run for 20 years, the patent term from the date of application, so it's not anything like, as we'll see in just a second, the length of a copyright term, but it's obviously a lot of time. And then we saw an Apple Samsung as we looked through what the jury did there. The bright change there, which is these design patents, which, as we looked at them in class, seemed pretty open-ended, in many ways less concrete, less bounded than a typical utility patent. Everyone, I think, thinks we're going to see an explosion in efforts to use those. The term for those is shorter, but practically that may not matter. All right, from there we went to copyright. The copyright system is designed to protect expressions of ideas, not facts. So we separate out the notion of what an author has done. An author hasn't created facts, and you're not allowed to control ideas. What you can control is your expression of the ideas, or your expression of the facts. And so drawing that line, separating on the one hand expression that is protected from ideas and facts that are not protected, the idea-expression dichotomy as we call it, that's obviously one of the tricky questions in copyright. There is no filtering requirement. There is, like the patent system, there is no quality bar. Is your poem good enough? Is your movie good enough? Nothing like that at all. Copyright arises the instant we have an original work of authorship fixed in a tangible medium of expression. And no filing is required to get that, though you have to file if you want to file a lawsuit. All of that means that copyrights arise with almost shocking frequency, and that's the sense in which it's a pervasive system of intellectual property. The core rights of the copyright holder, the statute defines those in Section 106, the right to control reproduction and the like. And then the way in which the copyright system steps back and says, well, we're not going to go this far. We're not going to say that you control the following uses, and those are what we call fair uses. Section 107 of a statute lays out a four-factor test for that, I think we're in the midst of a transition where we're seeing more aggressive cases finding fair use. So the Hathi Trust case, that's Hathitrust, which came out very recently, and which is going to enable more use of mass digitization at least in academic settings and maybe in the Google Book search setting, is a recent visible example of that. The Grokster decision, part of the reason to read that case is to make clear the gap between what happens in law and what happens in business. So the music industry, in some basic sense, has been very successful in litigating. Won cases involving Napster, won a Grokster case. Maybe not on the theory they expected to win it, but they won the case 9-zip on the inducement theory. And notwithstanding that, it's not clear that the litigation strategy has done what they want, which is to provide meaningful protection for copyrighted music on the ground. Not obvious that's happened. On trademarks, did a little bit less content there, but the key idea here is that we want to have cheap, reliable symbols to indicate the source of products. That is the heart of trademark law. And so it's again a way in which symbols are going to be protected, and protected so as to make the content of those symbols meaningful. If I could attach the Nike swoosh to everything and everyone else could do the same thing, but all of a sudden the swoosh ceases to have meaning. It doesn't tell me it's really coming from Nike. And so the power of the swoosh to indicate source would be diminished if others could use it. We talked about a few other things as well, but that is the core of what we did on that day.